Guys, have a look at this. Judge Torres ruling on XRP secondary market sales challenged by XSEC official, both Coinbase and the United States Securities and Exchange Commission. Selling XRP on the secondary market is now subject to a ruling by Judge Torres. Judgment rendered by Judge Catherine Filla in the matter involving the two organizations crypted by an ex-official had a profound impact on both Coinbase and the U.S. Securities and Exchange Commission. But the SEC did win something, even if it was only a partial triumph in the ruling. Judge Filla vehemently disagrees with Judge Torres' ruling in the Ripple versus SEC case, which held that secondary sales of XRP cannot be regarded as investment contracts or unregistered securities, according to John Reed Stark, a former chief of implementation for the Securities and Exchange Commission. In its plea for a final judgment against Ripple, the Securities and Exchange Commission has approached the court. In addition to fines and penalties amounting to almost $2 billion for infractions of federal securities laws, the former SEC challenges the judge's ruling in the XRP case. Former head of the SEC's Office of Internet Enforcement, John Reed Stark, said that Judge Follett's decision to totally invalidate Judge Torres' reasoning in Ripple's decision, that secondary sales cannot be considered, was the biggest setback for Coinbase and Ripple. When making an investment, it is important to know who you are buying from before you commit. If you believe Judge Filla's statement, secondary market transactions involving crypto assets might technically be deemed investment contracts. When deciding whether a certain transaction qualifies as an investment contract, the Howey test states that courts must look at the deal's economic reality. Contrary to what the defendants claimed, Judge Filla rules that whether an investor bought tokens directly from the issuer or through the secondary market does not always determine whether any specific transaction in a crypto asset constitutes an investment contract. Contrarily, Judge Torres reached the following ruling in U.S. Securities and Exchange Commission v. Ripple Labs. A buyer with institutional knowledge bought XRP from Ripple directly under the terms of a contract. In actuality, though, a programmatic buyer was no different from a secondary market buyer in that it had no idea who or what it was paying for. John Dayton fully endorses the Torres doctrine's articulation of the Howey test as it pertains to programmatic sales. However, in Coinbase versus SEC, Judge Torres chose not to consider secondary market transactions. It was decided following Judge Follett's decision, the case will move on to discovery and eventually a jury trial because Coinbase was determined to have engaged in the unlicensed offer and sale of securities through a staking scheme. Coinbase will depend on its legal arguments while the lawsuit is proceeding. A number of charges have been leveled against the firm by the Securities and Exchange Commission, including that it operates as an unregistered broker. In contrast, the court tossed out the part of the lawsuit that challenged Coinbase's status as an unregistered wallet broker, even if some tokens met the criteria for an investment contract. The court ruled that Coinbase was not a brokerage. This was the verdict handed down by the judge. Fred Rispoli, an attorney, is looking into Ripple's XRP price when the SEC is suing the company. Some have claimed that Ripple offered steep discounts to institutions, which has prompted a heated discussion. Significantly, Ripple has responded to the SEC's request for a $2 billion fine in the ongoing dispute, while his client Ripple and the U.S. Securities and Exchange Commission are embroiled in a protracted legal battle. Attorney Fred Rispoli looks into the cryptic price of XRP. The degree of transparency and equity in the cryptocurrency industry has come under scrutiny after claims of discounted institutional sales sparked controversy. Attorney Fred Rispoli has shed light on the mystery of Ripple's XRP price amid a lawsuit filed by the SEC. Claims of steep discounts at venues run by institutions cause controversy. Will XRP investors be hit the hardest by the lack of transparency, or will they be spared? The result will depend on Ripple's next move. At issue here is Ripple's sales strategy, according to which the company offered XRP at steep discounts to some institutional buyers. Here's where the debate started. According to Rispoli's research, this method might have contributed to the comparatively low XRP pricing on the market. However, the SEC claims that regular investors who bought XRP at higher prices initially lost out because to the price discrepancy caused by such preferential treatment. The SEC's motion, which urges a staggering $2 billion penalty for Ripple, demonstrates the gravity of the situation. As this regulatory body argues that investors were unfairly treated because Ripple's sales strategy violated security standards and lacked transparency. In addition, according to Rispoli, market volatility could be exacerbated if institutions are offered discounts on purchases, especially when prices are rising, as these institutions may sell large quantities of excess. During price rallies, this is particularly the case. This might work against retail investors who are tasked with helping institutional players access liquidity upon withdrawal. The result of the legal matter is still uncertain, despite the fact that Ripple is currently drafting its answer to the SEC's motion. The outcome of the settlement is expected to significantly affect the price dynamics of XRP and the industry's ability to comply with regulations regarding cryptocurrencies. Regardless, Ripple and its investors will face significant consequences. To fix the pricing mystery and win back the trust of XRP and investors, Ripple must take the next step. The reason behind this is that Ripple is presently dealing with an increase in legal concerns and scrutiny. When will the XRP and SEC dispute ever be resolved? Scott Melker, author of Wolf of Wall Street, and James Murphy, thoroughly examines the intricacies of the SEC's damages theory in the Ripple case, highlighting what he perceives as a fortunate development for the cryptocurrency company. What does the SEC harm theory mean in light of a ruling by the Second Circuit Court of Appeals? He raises a significant concern over a precedent that says the SEC must prove wrongdoing by naming victims who have lost real money. By shedding light on the SEC's losses theory, Melker highlights a major problem. It is impossible to determine which XRP users have lost money. Contrarily, the SEC's argument rests on the premise that certain buyers acquired XRP at discounted rates. Since this claim fails to provide evidence that specific companies have incurred monetary losses, it exceeds the limits of pecuniary harm. The SEC's case is significantly weaker than it could have been because they have failed to identify specific victims who have endured real monetary damages. When there are no identifiable victims, the deterrent concept, which aims to return illicit revenues to those who have been harmed, is essentially useless. This calls into question the validity of the $200 million interest claim that the SCAC has made, as it is contingent upon the presence of consumers who have been discouraged from making purchases and have suffered financial harm. There may be a snag in the crypto market analyst timetable for XRP to hit the lofty $100 price objective. The current bull market has put XRP in the spotlight, but not in a good way. Coins like Bitcoin and Ethereum have risen by 65 and 53 respectively this year, while XRP has risen by a meager 1.28. Both new and experienced investors are worried about this sluggish growth rate, but new price increases are on the horizon, with some market watchers citing XRP's similarly poor performance at the beginning of the 2017 bull run as evidence that the cryptocurrency will eventually beat the market. Forte recently went on X to share his projections for the cryptocurrency business in 2037, a full 13 years away. A $100 price point for XRP is one of the predictions made. From where XRP is now, the $100 price would be a 15,950 wine rise. Not to mention that in June 2022, XRipple director Matt Hamilton came out about his belief that XRP may and will hit $100 in the future. Retired Ethereum advisor Steven Naroff said last October that XRP may hit $100 if given the chance. Although these forecasts have dominated community discourse, none of these commentators have offered any concrete timeframes, unlike Forte, who has provided a forecasted timescale for 2037. That's all for now.